Hi, Colby here, and welcome to Hold My Briefcase, where we talk about real legal issues and real legal tips and real legal secrets so that way you have the knowledge and the education so you can be informed and equipped to handle any situation. My name's Colby. I'm the managing partner of the law offices of Colby Lewis. This podcast is designed not only for laymen or regular people, but it's also designed for a practitioner who just may want to refresh. And I mention that today because we're going to be talking about mediation. Mediation is a type of what's called alternative dispute resolution. And this is going to be what I like to call Mediation 101. What is it, how it works, and why it might be the best move in your case. Whether you're a client wondering, do I have to go to trial, or a lawyer looking for a refresher, this episode is for you. What is mediation? Mediation is a structured negotiation process where a neutral third party, the mediator, helps the parties reach a voluntary agreement, right? And the first thing you got to notice there is that the mediator is a neutral third party. They'll keep your secrets. So if you tell them, hey, look, I'm going to argue for this, but I really will take this, the mediator is there to listen to you and get you the best result possible. They're there to be as a neutral. So what they typically do is they'll come in and listen to you and then play what's called devil's advocate. Well, have you considered this? Have you considered that? And remember, the mediation is not a trial, right? A trial is final. You have an arbiter of facts. If one person says the light is red and the other person says the light is green, the jury is going to get to decide who they believe. The mediator doesn't. Mediator doesn't care. Mediator is there to try to resolve your case. It doesn't decide your case like a judge or jury. Just helps facilitate discussion, move both sides towards a resolution. A lot of times when we're dealing with these disputes, we're personally involved and we have a personal stake in it. It's very personal to be injured, to be hurt, to have to deal with it every day. But the other side doesn't see it the same as you. A lot of times the other side is just an insurance agent who doesn't even really know your name or care. They're just looking at this like a number. And the mediator's job and my job at mediation is to show that this is not just every other cookie cutter case. Demonstrate what it is and why it is my client deserves resolution. And mediation is used in a lot of ways. Sometimes it's court ordered, which means that the judge requires you to go to mediation. This can be unfortunate, especially if your case is a smaller amount, because mediation costs money, $750 sometimes per side. And in many cases, and in fact, in all cases, if you have a successful mediation, you'll forego the need for a trial. So you resolve the case, you don't have to have a trial. That's what mediation is hoping to prevent. Now, you hear us talk a lot about being hard and being strong and relentless representation for our clients, but trial is not always the best, right? There are some benefits to mediation. And one of the most important that my clients appreciate is that they're going to have control over the outcome. In a trial, a judge or a jury gets to decide, right? They get to decide what happens. They get to decide your outcome. But in a mediation, you get to decide what works best for you, right? You get to determine if I'm going to take this number, if I'm going to take this resolution. It's not forced upon you. Also, it saves time and money. For example, I have a trial coming up in Dallas, and in order for me and my team to mobilize and my trial team to be there, it's going to cost money. You have to fly the attorneys, you have to board the attorneys, you have to feed the attorneys, although I only feed them McDonald's. But that adds up, right? We can forego all this, and if we're still getting a similar result, then it makes sense, right? And it's a lot faster. Right now, the jury trials are taking years because the courts are so backlogged. And the backlog of the cases means that the courts where the clients are seeking justice, they're having to wait, and they're having to wait. And even when their time comes up for a jury trial, it gets passed. Through no fault of the attorneys, it's just there's not enough throughput. There's not enough people. There's not enough time in, say, Harris County. Mediation is useful, and courts believe that it's helpful because it will dispose of cases without having to do trial, which means that it allows these cases to resolve without putting pressure on the county's resources, the county's employees, right? And for that reason, some courts require mediation before trial, and this is especially true in civil cases. But even if it's not required, judges strongly encourage it because it reduces, as I said, their case load, and it helps people reach practical solutions, right? If you have a release that's signed at the end of the mediation, you're going to get resolved. You're going to get a check. You don't have to worry about going through collections. You're not going to have to worry about them going through bankruptcy. It's going to get resolved, and you can move on. So that brings us to the question, why should you settle the case, right? And instead of leaving your fate to 6 jurors, you and the other party get to work